Dr. Charu, should we start now?
Dr. Achal, we can.
Yeah, thank you so much. And welcome everyone to EBC Learning and to this interesting webinar on a very important case, Indra Sawhney versus Union of India, popularly known as the Mandel Commission case. Now, let me introduce Dr. Charu to you all. Dr. Charu has already conducted two more successful AOR cases at EBC Learning. She has a rich and diverse expertise in corporate, commercial, civil, criminal, and constitutional law matters. She is an advocate on record, Supreme Court of India. She has recognized parties, which include cricketing bodies and educational institutions like IIT Jodhpur, NLU Jodhpur, and other private engineering and medicine colleges of Gujarat and Orissa. Dr. Charu is also a passionate academician and has authored various courses at EBC Learning. She has done various modules on corporate law, insolvency, negotiable limitation. And let me tell you, this 1 hour of learning with her will be very useful for you for your future endeavors. I request everyone to please mute themselves. And now we at EBC Learning have developed many courses which are both skill-based and foundational. And let me tell you, these are very much rigorous and comprehensive. We have various courses in our portal. The live course, which is currently happening in our upskill diploma in advanced corporate law in collaboration with CII. This is the most extensive live course on corporate law. And also shortly, we'll be doing the EBC Learning Bennett University Mastery Certificate in Advanced Corporate Law. Also, this is an on-campus program, an offline one. More details are on our website, and let me just take you through our website first. So just give me a moment. I'll just share my screen with you. Now, I hope you all can see my screen. So this is ebclearning.com. When you open this website and you land on this page, and you can see the various courses which are there on the right-hand side of the page. And we have got various courses, instructor-led courses, instructor-led path, self-paced courses, which are 51 in number, and various talks as well. Competitive examinations also, we have done various courses on competition examination, law school, legal skills, and practice. As you can see on your right-hand side, we have arbitration step-by-step, we have contract law essentials, we have RERA essentials by Dr. Charu herself, then we have handling check bounce cases, we have insolvency essentials, one of our most popular courses in which various modules, updated modules have already been there on our website for you to watch. Then we have Consumer Protection Act, then we have how to create a will, we have corporate law essentials, 5 modules on corporate law essentials. And so all these courses are here, and all these courses comes not only with the videos, but high quality videos, but with the examination pointers, assignments, relevant sections, and links to the full text of cases and Supreme Court on Supreme Court SEC online. So basically, when you actually sign on with us, you will sign with you sign up with an extensive learning, which is obviously comprehensive and rigorous, and it practically includes each and every aspect of learning. And now coming up to our most popular course, which we are going to start shortly, is on the Aor course. More on this from Dr. Charu. I think I'll just, this is the one, this is the instructor-led course. So this you can enroll by 15th of June, and the end date is 6th of July. So all the details are on our website. Now I would request Dr. Charu to take it over from here. Dr. Charu, over to you, and thank you so much, everyone.
Thank you, Dr. Achal. So good evening, everyone. Thank you, Dr. Achal, for a very kind introduction. And this is an ongoing series that we are trying to do. Last week I did Jarnal Singh case with you, and today I'm going to do Indra Sawhney case. Now, before we start talking about Indra Sawhney, it is one of the leading cases for your exam. And even if you are practicing in Supreme Court, and if you are practicing, your area of practice is service and educational matters, which is my area. So you have to understand this case in great detail. Now, before I start with this case, I would just like to put on few things. Now, as far as India is concerned, every Indian, right, who is born post-independence, right? Most of us are, right? And in fact, we are after 30, 40 years of independence. We have at some point of our time have come to have to deal with this concept of reservation. Now, what is a reservation? Reservation, if you look at the other countries like US, they call it affirmative action. In other places, it is called positive discrimination or compensatory discrimination. This is essentially to give advantage to the people who have been historically disadvantaged group. Now, how does India implement its reservation? It implements its reservation by providing percentage-based quota in favor of the citizens who are traditionally from this disadvantaged group of this disadvantaged group. Now, if you go back in the history, if you look in India, this reservation you will find is closely linked with your caste system, right? So as far as caste system is concerned, you know, there were 4 varnas. There was a Brahmin, Kshatriya, Vaishya, and Shudra. And apart from this, of course, these first 3 will come under the higher grade, and thereafter you will have a lower caste Shudra. And then there is another class of Dalits, which were untouchables. You know, the untouchability is being banished from our land by the way of making it a fundamental right that you cannot call a person untouchable, right? Now, this is a general background I am just giving you. Now, the thing is that there is sea change in the attitude of people. Everybody wants to be come under any of the subcasts which can be classified. There is a scramble amongst people that I am more backward than you are. People get fake caste certificates, they get fraudulent income statements, etc. And today, if you look at India's situation, you will find that at least 500 million or even more that will come under some sort of reservation that they will see. Now, if you look into India, you will find that they are broadly classified as scheduled caste, which comprises of Dalits, scheduled tribes, which are the tribal communities living in the isolated part of India. And then there are OBC or other backward classes, which are socially and economically backward, right? And even you can add educational. Now, reservation for OBC, it has been one of the most contentious issue, right? It has received large amount of backlash in many parts of India. And the heart of this controversy is being adjudicated by the Supreme Court in the judgment called Indra Sawhney versus Union of India. Right? I remember I was in 10th in 1992 when this agitation against reservation was going on. And till date, that image in the newspaper where Rajiv Goswami, a student of Delhi University, he self-immolated himself, and then 100 or so other students across the country, they started self-immolating. So Supreme Court, it had to intervene in between, it got stay. Then there was a checkered history, the government fell, there was another election that went on. I will be taking you through that timeline in the slide, but this is what I am telling you. So before I take you through the nitty-gritties of this reservation under Indra Sawhney, I would just like to give you a brief history that how the organized reservation came into being. So if you look that there was a Maharaja of Kolhapur, Shahuji Maharaj IV. In 1902, he took the first organized step to provide reservation for backward classes in India, and his idea was very noble. He wanted to eradicate poverty in the backward classes, and he wanted them to be more inclusive to be in the public admin. So this was fine. He did it with a noble intention, but Britishers came and they developed their religion and caste-based policies for reservation. So what was very critical for them was to have a religion and caste-based theory. And then in 1909, if you have read Indian history, you would be knowing it was a year which reforms came. Morley-Minto reforms came in the form of Indian Council Act of 1909, which provided for separate electorate for Muslims and reserved seat in their municipal and district board, provincial council, and even at the legislature. The Government of India Act of 1919 and 1935 also had provisions for this reservation. Now, if you are a serious student of law, my suggestion to you is you must find time to read the Constituent Assembly debates, right? So, this Government of India Act 1919 and 1935, which actually provided, Government of India Act 1935 actually provided the broad framework for providing integrate reservation work. Now, if you look at our fundamental part 3 of the Constitution, you will find Article 14, which says it gives all the people of right to equality before law. But then there are various other sections also, which are, there are various other articles also which provide that there should be no discrimination in education, there should be no discrimination in the public employment. Under Indra Sawhney, currently we are concerned with Article 16, subclause 4. Right? Article 16, subclause 4, it provides state to make provisions for reservation of appointments or posts in favor of the backward classes which are not represented adequately in the state service. Thereafter, if you look at the constitutional provision, you have Article 46, which is the directive principles of state policy, which provides that the state must have promote the education and economic interest of SC and ST. Thereafter, you need to look at Article 340 of the Constitution, which authorizes the President to form commission to make recommendation for improving the conditions of the backward classes. And if you have attended my last session on Jarnal Singh, you would have come across Articles 341 and 342, which lays down the presidential lists, which identify that who are scheduled caste and scheduled tribe. Right? Now, before I take you through the slides, there has been a lot of criticism that reservation is pro-Hindu, since reservation policy was primarily aimed at abolishing Hindu caste system. Muslims, they have not been significantly disadvantaged group is there, but they were unable to avail the benefits of affirmative action in India. So this is the pre-constitutional scheme that is coming. And in the post-constitutional scheme, right, the first, I have again told you in Jarnal Singh that first thing that came before the Supreme Court was the case of State of Madras versus Champak Doreen. In the case of Champakam, there was the colleges in Madras which has implemented detailed quota-based reservation, and Supreme Court had struck down that they are opposed to Article 29(2) of the Constitution, which says that no student can be denied admission in institutions which is managed by state or receiving fund. Now, as a reaction to that, Parliament amended Article 15 of the Constitution, and it added that states can make provision for advancement of socially and educationally backward classes, that is SC and ST. So, by 1951, the provisions for reservation in educational institution and public employment was constitutionally mandated under Article 15 and 16. Now, with this, I'd just like to share my screen with you. Now, this is just a timeline that I have prepared for you to understand. So, this is a timeline when Pandit Nehru was the Prime Minister. In 1947, Union of India it affirmed that action for depressed class, scheduled class and scheduled tribe. Remember, the term which is used was depressed class and not OBCs or backward classes or any other thing. However, there was no list of the country of other backward classes which were less backward than SC and ST. So, SC and ST are the most backward. Then government in 1953, it commissioned a Kaka Kelkar commission under Article 340 of the Constitution to ascertain who are socially and backward classes of India and what can be done to improve their situation. Now, it's Kaka Kelkar committee, it traveled across India. It did extensive study for 2 years and it submitted report. It didn't ask for the reservation as something, but it said that government must do something to eschew the caste-based reservation to poor of all communities is what it demanded. It identified around 2,400 caste as socially and educationally backward class. Kaka Kelkar committee was put into the cold storage. Nothing was done to it. One reason was it was very vague. It didn't give actually what is to be done. Then, when Nehru was the Prime Minister in 1961, central government wrote to the state governments to devise their own criteria for defining backwardness. So each state was given as to who is a backward in their state. So all state governments, they started appointing their own commission, which gave reservation in services to backward classes. Central government in central services reserved only for SC and ST and not for any backward classes. So this was the scheme till Pandit Nehru was the Prime Minister. He didn't get you this reservation in the education, but he provided that there should be more education. Central government didn't provide reservation to OBCs, but only to the SC and ST. Now, then Indira Gandhi came and thereafter there was emergency and Morarji Desai became the Prime Minister. Now, Morarji Desai, when he was the Prime Minister, he commissioned a backward commission under BP Mandel, who was the former Chief Minister of Bihar. And this Mandel Commission was commissioned on January 1799, and by December 1980, this Mandel Commission had submitted report and it identified 11 broad criteria for backwardness under 3 broad heads of social, economic, and educational. For social backwardness, it gives 2 points. For educational backwardness, it gives 2 points. And for economical backwardness, it gave 1 point each. If you read Indra Sawhney's judgment, you will find that all of these criteria are very detailed and they are provided there under. Now, this Mandel Commission, what it did, that it also prepared a list of central and state OBCs. Now, for which I think this should be 31, not 61. So, source for this list was Economic Survey, then Census of 1931, personal knowledge of extensive tool, and the list of OBCs which were prepared by the state. Additionally, it adopted rigorous tests to identify who can be OBC amongst Hindus and who can be OBCs amongst non-Hindus. So, non-Hindus were also given reservation under this BP Mandel or the Mandel Commission. What it recommended, what it found was around 52% of the Indian population based on 1931 census was would belong to OBC reserved class, SC, ST and OBC. But then they realized that if they give 52% reservation and already there was 22.5% reservation, then it will become a very terrible situation. And they said that nothing would remain for the general classes. So it recommended reservation of 27% for OBCs. Now this Mandel Commission was laid before the Parliament in 1982 and 1983. This was the time when Indira Gandhi was the Prime Minister. She did not take any action on the Mandel Commission report and it let it be like that. Then, as you know, Indira Gandhi was assassinated. Rajiv Gandhi became the Prime Minister. Rajiv Gandhi was also assassinated. And in 1990, VP Singh became the Prime Minister. Now, when VP Singh was the Prime Minister, then on 13th August, this is an important date which you must remember, 13th August 1990, he came out with the first official memorandum which provides for 27% reservation for OBC. So you see this Mandel Commission has submitted its report in 1980. No action was taken for a decade. Then even Twice it was placed before the parliament, but no action was taken. Then, as I told you, there was the wild protests which were going on. There was self-immolation by students. See, please unmute your mic. Please mute your mic. Right. So there was wild protest by self-immolation by students. Indra Sawhney at that point in time was a journalist, and she became a lawyer also. She filed a PIL when she saw the plights of students which were on road, right? And there was a heavy protest. If you look at the papers of that time, you will realize how big an issue it was and what a huge Pandora box was opened. So on 11th September 1990, this poem of 13th August 1990 was stayed by the Supreme Court. There was fall of this VP Singh government, and elections were held in the first half of 1991. When the elections were held, by this time Rajiv Gandhi was assassinated and Narasimha Rao became the Prime Minister. Narasimha Rao on 25th September 1991, again an important date even from your point of view exam, issued the second OM, that is the official memorandum, which provides for 10% economic reservation in addition to 27% reservation. Now, there was no scheme as to how to provide this reservation till this judgment was pronounced on 16th November 1992. So what Narasimha Rao did was he started providing for 37% reservation, 27% for OBC, 10% for economic reservation. And various states like Rajasthan, they had actually implemented that also. The matter came before 2 bench, then 3 bench, 5 bench, 7 bench, and eventually it came before the 9 judges bench. Now, this was a split verdict. There were large number of opinions which were there. Majority view was given by 6 judges. This was it was held by Justice Kania, M.H. Kania, Justice Venkatachalaya, Justice M.D. and Justice B.P. Jeevan Reddy. Justice B.P. Jeevan Reddy wrote the opinion on behalf of himself, Justice Kania, Venkatachalaya and Justice M.D. Then there were 2 more concurring separate opinions, one of Justice Pandian and another of Justice P.B. Sawant. Minority dissenting view was given by Justice Thomanan, Justice Kuldeep Singh, and Justice R.M. Sai. If you have time, do try to read all these opinions. Now, this was, if you see the last time when we did the Jarnal Singh's case, I told you about section 16(4)(a), 16(4)(a) and 4(b). Now, when the Indra Sawhney judgment was there, at that time, this is what Article 16 of the Constitution read as. So, Article 16, it provides for equality of opportunity in matters of public employment. It provides that there shall be equality of opportunity for all citizens in the matters relating to employment or appointment to any office under the state. No citizen shall on ground of religion, race, caste, sex, descent, place of birth, residence, or any of them be ineligible for the discriminated against in respect of the employment. Then third, it says that nothing in this article shall prevent Parliament from making any law prescribing in regard to a class or classes of employment. Very important, it does not say caste, it says class of employment or appointment and office under the government of India. Who is there? Mr. Tiwari, are you asking something? If not, then please mute yourself. I'll take your queries later. Okay. Now, very important thing from the point of Indra Sawhney's judgment is 16(4). 16(4) provides that nothing in this article shall prevent the state from making any provisions for the reservation of appointments or posts in favor of any backward class of citizens, which in the opinion of state is not adequately represented in the services under the state. So for purpose of Indra Sawhney, you need to understand, remember 2 things. First is 16(1), which says there shall be an equality of opportunity for all citizens in the matters relating to employment or appointment to any office under the state. And 16.4 says, so 16.1 is saying equality of opportunity for all citizens, while 16.4 says that state has right to make provisions for the reservation of appointments or posts in favor of backward class of citizens, which in the opinion of states are not adequately represented. Now, before I take you to anything else, because this is a huge judgment, what I suggest you is that you follow the questionnaire which was formulated under this case, right? There were large number of writ petitions which were filed, there were transfer petitions were there. Eventually, court framed the question and it again reframed the question, and these are the questions which are provided. Now, question 1 was whether the provision which is contemplated by Article 16.4 must necessarily be made by the legislative wing of the state. If the answer to clause A is the negative, whether an executive order making such a provision is enforceable without incorporating it into the rules made under the provision to Article 309. Now, why do you think this question is there? Whether the provision contemplated by Article 16.4 must necessarily be made by the legislative wing of the state. Now, the answer to this is because it was what was under challenge were two official memorandum. One of 13th August 1990 and another was 25th September 1991, which was providing reservation for 27% of OBC and under VP Singh and 37% under Narasimha Rao, 27 for OBC and 10 for economically backward. So the question was whether you need to have only a legislative wing can do that. That is to say that only parliament can they do it when we're talking about the central list. So they asked whether it can be done only by the parliament or it can be done by the executive council. So the answer to that was, it is not necessary that the provisions under Article 16.4 should necessarily be made by the parliament or by the legislature. Such a provision can be made by the executive also. So even by an official memorandum, they can issue it. They can do so by a GO also, government order also. Local bodies, statutory corporation and other instrumentalities of state which falls within in the meaning of state under Article 12 of the Constitution are themselves competent to make the provisions if so advised. So they held this GO that they have a power to make this official memorandum. They didn't, in this first question, they didn't say whether this OM is good or bad. Second question, 1B was, an executive order making a provision under Article 16.4 is enforceable the moment it is made and it is issued. So if there is an executive order, if it is made under Article 16.4, it is enforceable right at the moment when it is made. With this, we move to question 2. Question 2 had 3 parts. The first part that the court framed was whether 16.4 is an exception to 16.1, whether 16.4 is exhaustive of the special provision that can be made in favor of backward class of citizen, whether it is exhaustive of the special provision that can be made in favor of all sections, class or group, and whether the reservation under 16.1 or whether permits only extending of preferences or concession. Now, this is a very important question. Try to digest the question first. First question is whether 16.4 is exception to 16.1. Second is whether 16.4 is exhaustive of the special provisions that can be made in favor of backward class citizen, and whether it is exhaustive of the special provisions that can be made in favor of all sections, classes or group, and whether reservations can be made under 16.1 or whether it permits only extending of preferences or concession. This is a very important point, and in this case, the court held that 16.4, it is not an exception to 16.1. It is just an instance and an illustration of the classification which is inherent in the clause 1. So it says that it is not an exception to clause 1. What does clause 1 say? Clause 1 says that there shall be equality of all citizens. I can just take you to clause 1. Clause 1 says that there shall be equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state. Now the question was whether 16.4, which states that nothing in this article shall prevent the state from making any provisions for the reservation or of appointments or posts in favor of any backward class of citizen, which in the opinion of the state is not adequately represented in services under the state. So the majority of the Supreme Court said that 16.4 is not an exception to 16.1. It said that it is an instance where you are giving an equality to all the citizens, and it is an illustration of the classification which is inherent in the clause 1. On the second question, the court held that Article 16.4 is exhaustive of the subject of reservation in favor of backward class of citizens as explained in this judgment. So you can read, this is a humongous judgment, and it will require, I have given you the para numbers also, so you can read it. So this is something which is exhaustive in favor of the backward class of citizens, which is explained in the judgment. Thirdly and fourthly, it said that reservation can also be provided under clause 16.1. It is not confined to extending to the preferences, concession and exemptions alone. These reservations, if any made under clause 1, have to be so adjusted and implemented so not to exceed the level of representation prescribed for backward class of citizens. So here what they said, that first they said that it is not exception, second it said it is exhaustive, and third it said that it is not confined to extended of preferences, concession or exemptions alone. These reservations, the court said, if they are made under 16.1, they have to be adjusted and implemented as not to exceed. Here, what is an important word is not to exceed the level of representation which is prescribed for the backward class of citizens. Then we move to question 3. Question 3 says, what is the expression backward class of citizen in 16.4 means? Whether backward class can be identified on the basis and with reference to caste only, whether a class is to be designated as backward class should be situated similarly to SC and ST, and then it said that whether the means test can be applied in the course of identification of the backward class. Swapnil, I'll just come to the queries after I just take you through all these. In the meantime, those who have queries, they can just type in the chat section. Now, whether the means test can be applied in the course of identification of backward classes, and if the answer is yes, whether providing such test is obligatory. So let us quickly see what Supreme Court said in this case. Now, in this case, Supreme Court said that a caste can be, and it says that can often be the social class in India. If it is backward socially, it would be a backward class if proposed in the Article 16.4. Among non-Hindus, it says there are several occupational groups, sect and denomination for historical reasons are called socially backward. They too represent backward social collectives for the purpose of Article 16.4. So what Supreme Court in Indra Sawhney said that who can be backward? It is the social class, right? Because what was the purpose of a reservation was to uplift the people who have been historically socially disadvantaged. It was not only for Hindu, but even for the other religion based on their occupational group, sects and denomination. Like for example, there are drishtis, they carry this, they put water along to clean the street this is skin of a certain animal in which they fill the water and they clean it. Right? They are also treated as untouchable, though they are not Hindu. So in this case, the court held that socially it is required. On question number 3b, the court held that neither the constitution nor the law prescribes the procedure or method for how to identify the backward classes, nor it processes advisable for the court to lay down any such procedure. So essentially the court says, the court ultimately said that who is a backward class of citizen? It is the some person who is socially backward. So it gave various tests. First was it said that you can start with the occupational group of the caste where they were found, apply that criteria. Thereafter, they said that you try to do for the other occupational groups, community and classes to cover the entire population. The court said that the central idea and overall objective should be consider all available groups, sections and classes in society. Since caste represents an existing identifiable social group, class encompassing an overwhelming minority of country's population can well be with it, then go to other groups or sections or classes. So essentially, court said that this is an exercise which is to be done by the backward commissions, right? So SCBC has to do this exercise to identify. And this cannot be done by sitting in your drawing room. You have to go out in the field and actually look out that who are the people who are historically disadvantaged. Now, Article 15, it deals with the educational part, and court said that Article 16.4, right? It is not correct to say that the backward class of citizens who are contemplated in Article 16.4 is same as the socially and educationally backward class, which is referred to in Article 15.4. 16.4 is much wider. The assent of 16.4 is of social backwardness. Of course, social, economical, and educational backward class are intertwined in Indian context, but it says that for public employment, what you have to see is social, you have to see the social backwardness. Thereafter, it came to a very contentious issue, which is of creamy layer. The court was of the opinion that creamy layer can be and must be excluded. So what is a creamy layer? If you take a glass of milk, then what is deposited, the fat which is deposited at the bank on the top of the milk glass, or what we call as malai, you have to remove that because they are already uplifted. People who are left, they should be given the provision or benefit of this reservation. So people who have become IAS officers, people who have become ministers, people who have become judges, you cannot call them to be, or their families, the coming generation, to be historically, socially disadvantaged because they have risen to that level. So they become creamy layer, and the court, in my opinion, rightly held that they must be excluded. It is not necessary for a class to be designated as a backward class that is situated similar to the SC or ST. So court has done away that it has to be somewhere like SC and ST, only then they can be given reservation. So it made it even wider. Adequacy of representation of a particular class in the service of the state is a matter which is the subjective satisfaction of the appropriate government. The judicial scrutiny in that behalf is the same as in the matter of subjective. So whether they are adequately represented or they are not represented, that is subject matter of appropriate government to look into it. They must collect the data and find it out whether they are appropriately located or not. Thereafter, Supreme Court came to the question 4, and it said that whether the backward class can be identified exclusively with references to economic criteria, whether criteria like occupation, income without reference to caste altogether can be evolved for identifying the backwardness of that class. So in this case, the Supreme Court held that a backward class of citizens cannot be identified only and exclusively with reference to economic criteria. So only on the basis of economic criteria, you cannot say that a person is a backward citizen. Now, you must be aware that this is an issue which is pending before the Supreme Court. In PIL filed by Janhit Sanhita, they have challenged whether this 103rd amendment, it provides for 10% reservation, whether it is constitutionally valid or not, as it breaches the 50% rule which is coming since M.R. Balaji. Now, I am also a part of a petition for Dr. Neil Aurelius Newms. I have filed a petition where we have challenged this again. There was not your phone say it was a notification, it was a press release where the government during the NEET examination has provided for 10% reservation for economically backward classes. Now, and 27% more to the OBCs. So on OBCs, Justice Chandrachud and the bench of Justice Chandrachud and Justice Bopanna has already given the judgment. What we have challenged in Dr. Neil is the criteria for identifying whether a person belongs to economically backward class. So right now, what government was doing was it was looking at something called Sino Commission. Sino Commission, and it applied that if some person whose annual income is less than 8 lakh rupees, right, he will be coming under the economic reservation, and then it has got 4 or 5 other criteria. We challenged that. So government during the course of this writ petition, they said that this needs to be relooked, and they formed a Pandey committee, which have again come out with this thing that these people, they cannot be called, that these people cannot, there need to be change in the criteria which was given by General Sinno's committee, and they have adopted 8 lakh limits. They stick to that. If a person's annual income is 8 lakh rupees, he is an economically backward in this country. So when you say your annual income is 8 lakhs, that means roughly a person is earning around 70,000 rupees per month, right? So in my opinion, this does not sound good. Though because if you see that around 90 to 94% of India's population earns less than 8 lakh rupees per annum. So they cannot be taken up as poor in my opinion. And if there is the government's intention is to that benefit should actually reach the poor. You know, everybody makes these fake EWS certificate and everything. And the people who actually needs the upliftment, they are not getting this. So this matter is sub judice and likely to come sometime in end of July or first week of August. And then we will see whether this criteria changes or not. Nevertheless, part of this because I was involved in this case. So I just thought I'll give you a brief outline of the matters which are still pending before the Supreme Court. Now it is on the fourth question number 4B, the Supreme Court held that it is, of course, permissible for the government or other authority to identify a backward class of citizen on the basis of occupation cum income without reference to caste. So, Supreme Court in Indra Sawhney clearly struck down second OM which provided for 10% economic reservation. Now, as I have told you that right now what is under challenge in other writ petition not filed by us is the constitutional amendment itself. There is a constitutional amendment done to provide 10% reservation. While in Indra Sawhney's case, it was an executive order which provides for that, and it was the one which has been struck down. The court further held that it is possible for governments to identify class of citizens as backward class only on the basis of income and occupation. There is no need to refer it to their caste. With that, we come to question number 5, which was whether the backward classes can be further categorized into backward and more backward classes. So in this case, the Supreme Court held that there is no constitutional bar to classify the backward class of citizen into backward and more backward category. So constitutionally, there is no bar, and in fact, the governments of the whichever the government is there, they are doing it to advance their political motive. Now we came to the extent of which the reservation can be made. So as I have told you while doing the journal saying, that in the Balaji's case, M.R. Balaji's case, we came out with this idea of 50% rule, which is enunciated in Balaji. So the question before Indra Sawhney was whether this 50% rule is a binding rule or it is only a rule of prudence or rule of caution. Second question was whether 50% rule, if any, is confined to reservation made under clause 4 of Article 16, or whether it takes all rights of reservation that can be provided under Article 16. Further, it asked, while applying 50% rule, if any, whether an year should be taken as a unit or whether the total strength of the cadre should be looked into it. And then it asked whether Devdasan was correctly decided. Now let us quickly look at the answers to this. So as far as the extent of reservation is there, it provided that reservations which are contemplated in clause 4 of Article 16, it should not exceed 50%. While 50% shall be the rule, it is necessary not to put out consideration certain extraordinary situations which are inherent in the great diversity of this country and the people. It might happen that in the far-flung areas where those who are inhabiting it, they might be totally out of the mainstream of the national and you can provide them more than 50. So it said that depending on the situation, it can be relaxed. There is no strict guidance that it should only be 15%. But Supreme Court said that if you exceed 50, you have to make it a case and you have to make this case with extreme caution, and you have to see that a special case is made up. Then court held that this rule of 50%, it should be applied to each year. It cannot be related to the total strength of the class, category, service or cadre as the case may be. Now this is again still a contentious, because we have two judgments. One is of B.K. Pavitra 2, which talks about cadre, and we have Janal Singh of 2022, which talks about that it has to, B.K. Pavitra 2 talks about the group, and Janal Singh 2 of 2022, it talks about cadre. So this is still not very clear how it should be there. And this was the judgment of Devdasan. It was overruled. We are not concerned much with that. Then there are other queries which are related to whether Article 16, it permits reservation provided in the matters of promotion. So in this case, if you have attended my previous session, you realize that Indra Sawhney said that Article 16.4 does not provide for reservation in the matters of promotion. So to circumvent this, government brought out 16.4a and 16.4b, and they said that even in promotions it can be given, when you can give reservations in the promotion. Then the question came whether it is anti-merit. In this case, to what extent are Article 335, 32 and 46 of Constitution are relevant. So in this case, the court held that while the rule of reservation, it per se cannot be called anti-merit, there are certain services and posts to which it may not be advisable to apply the rules of provision. At this context, I would just like to read you to read judgment of Justice Chandrachud on what is a merit in our case in Dr. Neils, while he was discussing OBC reservation. He mentions that as to what is a merit. Does only getting marks will determine your merit, or what is a merit in general? It is a good piece to read that particular judgment. Thereafter, the court asked to what extent the judicial review is restricted with regard to identification of backward classes and the percentage of reservation made for such classes to be demonstrably perverse identification or demonstrably unreasonable percentage. So this was a question on judicial review, and it is in this case, the court held that there cannot be any particular standards of a judicial scrutiny which can be applicable to matters of under Article 16.4, and the court says that it has to be decided only on the basis of each and every question, each and every situation as and when it arises. Again, there were two more queries which were formed. First was whether the distinction made in the second memorandum between poorer section of the backward class and others is permissible under Article 16, and whether the reservation of 10% of the post in the economically backward section of people who are not covered in the existing scheme, which is made by OM of 25th September 1991, is it permissible under Article 16? So the court says that this distinction of making the poorer section, that is of providing 10% economic reservation, the court held is not valid. The court says that if you have to go for classification, it is to be understood and operated on the basis of the relative backwardness among the several classes who are identified as OBC. And it says that the reservation of 10% in the post in the favor of other economically backward section of the people who are not covered in any of the existing scheme is constitutionally invalid, and it accordingly struck it down. The court further held that Government of India and state government, they have a power, they have the mechanism to create a permanent commission for examining the request for inclusion and complaints of over-inclusion or non-inclusion as to who will go in the list of OBC or not. And this advice of the commission will be binding on the government. However, if the government does not accept this recommendation, then it must record its reason. Then the court did not go into whether this Mandel Commission was correct or the exercise which was done it was correct. So it said that it is unnecessary to send the matter back to the bench of 5 judges. So in this case, the court held that as far as reservation was concerned, so they said that you cannot provide reservation only on the basis of economic criteria. They said that government can provide the reservation. It said that Article 16(4) is not an exception to Article 16. Now, it also said that creamy layer must go. Those who have attained the benefit, they should allow the other citizens to give the preference to rise in the society. Now, in my opinion, see, India was not such a divided class when we started off, right? So by this, it has become a major political religious issue. And with this judgment coming down on 16th November 1992, this controversy around caste and political and religious issue has burned down. But at the same time, you need to look at it, that why did it burn down? Where the students were running on roads, and they were on street, and they were self-immolating. On 6th December 1992, you had another event that was of demolition of Babri Masjid. So that was a time when the country was totally engulfed in caste and religion politics. And India is never same since this implementation of Mandel Commission by VP Singh. Now, the government have extended Mandel Commission even to the education, right? It has started providing reservation in the higher education also. So even when you do your NEET PG or NEET super specialty, there are reservations which are coming. But if you look again, everything you have to look at the socio-economic politics. Then there were coalition government, and when the UPA government came, it came out with something known as Central Education Institution Reservation in Admission Act 2006. So this act, it provided reservation for 27% of all seats in government funded institution would be reserved for OBC, right? And this was again challenged. You have the host of decisions which were there. The Supreme Court in this case has again upheld the validity of the Central Education Reservation Act, and that is how you got a reservation crept into the education, higher education also. So the court held that 27% OBC quota, which was upheld in Indra Sawhney, the court reiterated that the benefit of such reservation would not be offered to the creamy layer of the backward classes. So, and thereafter, the Supreme Court in 2012, it came up, it upheld, in fact, the extension of reservation policy to the primary education also. The Central University Act of 2006, it provided for higher education, and in 2012, Right of Children to Free and Compulsory Education Act 2009, it upheld for reservation policy to primary education institution as well, where they were provided 25% of the seat to be reserved to the people belonging to socio-economic backward classes, SC and ST. So in this case, by 2:1, the court upheld the provision, and they found that the reservation is valid. Now, right now also there is this controversy is going on whether there should be a caste census or not. So this was a demand which was again put in 2011. At that time, UPA government was there, and it has decided to conduct the caste census in India. So the first caste census, which was done under British in 1931, and that is the basis of all the reservations that is done. There is still no caste sanction, and the government said in 2010 that they want to delink the regular population census from the caste census. So this is an unhappy situation. Not only is there is an additional cost, what is more that you won't get the caste figures and not meaningful or relevant when you look in the isolation from the information collected from the regular population. So right now also there is a long debate. There is a long debate as to whether there should be a caste census or not. Now there is this NSSO, that is National Sample Survey Organization, in its report of 1999 and 2000, it mentions that OBCs are around 36%, and then it says they have come to around 41% of India's population in 2004 and 2005. But Mandel Commission report in 1980, it estimated OBCs to constitute 52% of the population. So what we actually need is to have a clear idea that how much population is under it and whether we can actually do away with the reservation. So what Nehru provided was only for reservation only for SC and ST. Further, these reservation in the central services were there for SC and ST. There was a pressure from the state government, so he asked that, okay, we can do it for the others as well. And after that, even if you look at this thing, for education and all, there was no reservation. They were started creeping by various governments, starting with Morarji Desai commissioning Mandel Commission, Indira Gandhi not taking it up, let it die for 10 years. VP Singh raising the honest head, and then Narasimha Rao providing for another 10%. And now present government is asking for 10% reservation via a constitutional amendment. So economic criteria per se is, in my opinion, not a bad way to look at it, but it has to ensure that the benefit reaches the last person. Now I am open to your queries. If you have any queries, please ask. Yeah, Mr. Rakesh.
Yes, ma'am. My question is, ma'am, if the creamy layer is excluded, then why SC/ST is not excluded as like creamy layer?
Right. So as far as in the OBCs only there have been a creamy layer which is to be excluded. SC/ST they are historically they are said to be historically backward, socially backward. So the government, yeah, I got your question. So why not remove? Why not remove them from the services?
Yes, ma'am, because there are SC/ST, they are doing again and again, coming from one generation to the other generation, like the CM or in my state there is CM that comes from one generation to other generation, and they are taking the rights of the SC/ST after one generation, then other generation, then other generation, then other generation, but it is not excluded, and they are very rich, and they have almost 20 to 30% land in our Jharkhand. Then what we have to do? How we can come against him?
See, again, I'll request you to go and check out this judgment of Jarnal Singh, which I had done with you. If you have attended, I'll just show you the slide.
Yes, ma'am.
Now, when I have done with this this thing, Jarnal Singh with you, I have told you that this Nariman's judgment it provides for exclusion of SC/ST if they come under the creamy layer. Now it is for the governments of the day which have to work out that you exclude. So under the Jarnal Singh's judgment, they have started excluding SC/ST also from the creamy layer.
Thank you, ma'am. Thank you, ma'am. And my second question is, ma'am, if any person in general class there are 63% reservation or 60% reservation, why people couldn't take this? If the OBC and SC/ST fill up the form in OBC and SC/ST, then why they not become in general classes if their percentage is high in that exam?
See, then they are getting on their merit. You cannot say that if you are SC/ST, then you have to take only in your category. It is not a category-wise reservation if I am filling a form as SC or ST, right, or OBC. But if I come higher up in the merit and I am getting that position on basis of my merit, right, because examination paper is not different for a general category candidate or a SC or ST. So if I come by my merit, in SC or ST, I will be given. This was a challenge before various courts, and court said that if you start providing reservation that if a person belongs to SC or ST, he should get only SC or ST quota seat, then this is like a communal reservation which the country is always against. The reservation is only merit based. If somebody is coming on his merit, he has to be given that place.
And third question is, ma'am, in our Jharkhand, there is a rule of 13 and 11. It means that there is 24 districts in our Jharkhand, but there is a rule of 13 and 11 that comes in your court also, ma'am, in Supreme Court also. People of Jharkhand is divided into two parts. In one part, it is open for all, but in 13 second part, it is reserved for their district people only, that they can get their job in that person, in that place. Those who born in that 13 district, they can get only job, like a SC/ST. There is a reservation of SC/ST for 13 districts. It is totally, for my opinion, ma'am, it is not good. But it is done, and there are 18,000 vacancies are in pending now. Then in BJP government, 2000 the vacancies will come in 2016, and the final result will come in 2019.
So it might be that they are the people that belt is essentially a tribal belt. So government is providing that. And I recall there was one Jharkhand matter which was going in Supreme Court before the bench of Justice M.R. Shah. I was waiting for my matter, but that matter was also going on. And I think state of Jharkhand has come in appeal. I don't know finally what happened into that matter. I think judgment is to be pronounced. It was done just few days before vacation. So if it is an entire belt, like there have been places where there have been 100% population is scheduled tribe. So you cannot say that only I will give you 15% reservation or 7.5% reservation or some reservation. You have to give them 100% reservation. There were some other queries. Yes, Mr. Swapnil is asking, as for the reservation is concerned, shall not exceed 50%. What was the bifurcation of the reservation among the caste who got benefit and who refrained from the reservation? So, see, again, this was based on the Mandel Commission report, and essentially during Nehruvian times, his idea was that reservation which is there, that was only for these parliamentary seats and not for all the educational institutions or in the higher education. He said that, okay, fine, we can provide some reservation in the entry stage of entering into a job, but all these subsequent governments, they have made it even applicable to the promotion. They have made it applicable to the higher education. Like I do a lot of NEET PG matters, medical matters, and one question which again and again comes, which is that why people who have done their MBBS, they have read at the same level, why are they getting reservation in the postgraduate? Why are they getting reservation in the super specialty? So actually there is no definite answer to that. And then you have got educational preference and all those things are also there in name of continuity. So this reservation is a big, essentially a political issue, right? Even if you look at this 10% reservation, which is under challenge, and where I have just challenging the criteria. So if you say that if a person who earns 70,000 rupees in India, is he poor? Can you call a person poor or a family poor if they are earning 70,000 rupees a month? I don't think so that we have become that rich that we call a person earning 70,000 per month to be a poor. If you look at the income tax data, you will find that people who file their annual report, annual income, then 94% of India, it files under 8 lakh rupees. And then we have a query from Mr. Janardhan. Why is Tamil Nadu reservation exceed 50%? Please explain. See, Tamil Nadu has its own thing, and they have been increasing in the reservation. Last year also they allowed it, but this year it was not allowed for the NEET admissions. So the government there is providing this reservation under the state quotas, and it should be challenged. So any other queries? Shall we call it a day then? Okay, then we can call it a day. EBC is starting with this Aor prep course from 15 June. You can have a look there also. And I think in few days I will be doing one more webinar, maybe touching one of these cases which relates to the reservation only, so that we can complete the entire thing. If there is any feedback, etc., do share with us what you would like us to work on. What are the areas that you all have the list of the leading cases. Any case in particular that you want me to cover, I'll be happy to do that.